hi, everyone. I'm Tamara Cruz, and I'm with ElderWorks. I'm a senior advisor to help families find any kind of senior needs, housing, and many, many resources. And today I'm happy to present one of our resources is Shire Law. We have Ellen and Caren with us today, and they are going to be talking about POAs and having how to protect yourself and healthcare directives and so forth. So they can do much better of a job explaining and introducing themselves. So Alan, I give it to you.
Thank you so much, Tamara. So I'm Alan Press.
I'm Caren Naidoff.
And we're both partners at Shire Law Group in Lincolnshire, Illinois. We're an estate planning and elder law firm. And we've been around for 28, at least I've been around for 28 years doing this type of work. And we're very excited to be here today to share with you this presentation.
So if you have any questions throughout the presentation, we love getting questions. Feel free to ask them. You can drop them into the chat, and Tamara will be monitoring those and we can answer them as we go. And then we'll also stay after for as many questions as you might have. If you have a question later on, we're going to put up some information about how to reach us in a moment.
So with that, I'm going to go ahead and share the screen and we'll get the... There we go. All right, then we're going to go ahead and start our...
All right, so thank you again for joining us for Peace of Mind, Protecting Yourself with Powers of Attorney and Healthcare Directives. And like we said, here's a little bit of information. If at a later time you want to reach us, you can go ahead and call us, 847-955-9000, or Caren, it's C-A-R-E-N at shirelawgroup.com, and Alan, A-L-A-N, at shirelawgroup.com. We really do welcome questions. So with that, well, let's get started. So what we're going to be discussing today is what you need to know about the interplay between powers of attorney and wills and trusts, the importance of powers of attorney and healthcare directives, why you should have them in place. And we'll also review the ideal planning of how you can protect yourself and your family, both now and in the future. The first thing we're going to do is do a brief overview of estate planning. And what is estate planning? It is the process of using an attorney to help you prepare for your future by planning for who you want your wealth, your assets, your property, and more to be gifted to after you pass away. And those people that you gift to are known as your beneficiaries. In addition to planning for who you want your wealth, your assets, your property more to be gifted, it's also about planning for how you want those gifts to be made for your wealth, your assets, and your property once you pass away. There's other pieces of estate planning, and those include directing your health care and guiding your finances during lifetime. So that's the topic of today's conversation, those important powers of attorney and healthcare directives, which we're going to explore in a moment. Estate planning also involves minimizing or avoiding taxes and minimizing or avoiding probate, which can be time-consuming and can also be expensive.
So we're going to start off just with brief conversations about wills and trusts, just so when we get to the part regarding the powers of attorney and healthcare directives, you have a little bit of a basis for what the differences are in these documents. So we're going to start off with just talking briefly about what is a will, or commonly referred to as a last will and testament. It can be referred to either way. And many of us know what this document is, either through personal experience or watching Dynasty on television or something along those lines. When a will is a document that somebody drafts, and they can designate in that document to whom they want to leave their property to when they pass away. A will is only effective at death. So this is kind of important to make note of, because when we talk later about powers of attorney and healthcare directives, those documents are only going to be valid during lifetime. So there's a difference there. A will would also allow you to designate a guardian or guardians if you have minor children and you wanted to provide a designated person to act as their guardian. And a will is basically going to instruct a probate court of who you want to receive what and how you want that to happen. So now let's switch over for a second and talk about what is a trust. Like a will, a trust is also a legal document that you prepare during your lifetime. If you're the person creating the document, you're called the grantor or the settlor or the trust maker. All of those terms are going to be interchangeable. And you create a document that, like a will, also provides for what you want to have happen to your assets when you pass away. But unlike a will, a trust is going to be effective immediately. So it's going to be valid during lifetime and also after death. It's going to allow you to streamline the administration of your assets, like we said, during life and also after death. A trust is popular because, unlike a will, it allows people to avoid the probate process. We don't discuss probate at too much length here, but that's a legal proceeding when somebody dies to handle the disposition of their estate. And having a trust will avoid that legal process and save some time and money. A trust is also going to provide privacy because it's not filed with a court and there's no probate proceeding. There's no public record or public inspection available of the document. So many people are drawn to a trust because they like the privacy aspect. Nobody gets to see it except for the family and the beneficiaries and maybe the IRS if there's some sort of tax issue or something like that. A trust is also going to allow the ability to have maximum control. Let's say that I have beneficiaries and I'm concerned about the way that they might spend my money when I passed away. Maybe they have an addiction problem or they're just not good with money in general, and you're concerned about that. Well, you can craft how and when they're going to receive the money, and you could even designate a trustee for those beneficiaries' benefit to control the money for them while they're alive. So having a trust is going to enable the trustee to carry out your wishes with a lot of specificity. If I said that correctly, to being very specific about what you want to have happen after death. So let's talk about a couple of things that are true about trusts. Trusts are going to give you control as to how your assets are distributed. If you create a trust, it needs to be funded, which means you need to put assets into the trust. Unlike a will where you just say, when I die, I want all of my assets to go as follows. A trust is only going to control what's in the trust. So you either have to title assets into the name of the trust, or you have to adjust your beneficiary designations to make the trust either a primary or contingent beneficiary. The trust is going to avoid probate. We've already talked about that. Trusts are private and easy to administrate. We've talked about that as well. And a trust, because it's effective during lifetime as well as after death, is a great tool to plan for potential incapacity or disability as well. So lots of nice features there in a trust. So if somebody dies without a trust or a will, then they die intestate. And what does that mean? So people always ask, well, geez, if I don't have a will or a trust, what happens with my assets? Well, the state of Illinois has a statute. It's called the intestacy statute. And that's going to determine who receives your assets in absence of a valid will or a trust. Now, it only applies, though, to probate property, which would be assets that the deceased person owned only in his or her name. It doesn't apply to joint property. If Caren and I have a joint bank account together and I were to pass away, she becomes the sole owner by virtue of being the joint owner of that account. Same thing with anything with a beneficiary designation. If I have a life insurance policy and my wife is named as the beneficiary of that life insurance policy, that doesn't go through the intestacy laws or the estate. It basically gets paid out in accordance with my beneficiary designation because that's a contract that I have with the life insurance company. Same answer with a retirement plan or something along those lines. And any property that's going to be held in a trust or is otherwise disposed of by a will Of course, you have the right to leave your money to whom you want to. So if you have a will or a trust and it says money should be distributed as follows, generally that's going to be followed. Now, in Illinois, if you pass away without a will or a trust, the statute says that if you pass away with a spouse and children, the spouse would get 50% and the children would get 50%. If you pass away without a spouse, but with children, children get 100% in equal shares. And if you pass away with a spouse but no children, then your spouse would get 100%. And that seems to make sense, but it could create, unintended results. So it's never a good idea to rely on this. We had a young couple once, and the husband owned the home, I think because maybe the spouse didn't have great credit or an inability to borrow money. So the home was in the name of the husband. He passed away prematurely, and they had 2 small children. So under the intestacy laws, his wife or spouse received 50% of the home, and the 2 minor children received the other 50%. And that was probably not the result they intended on, especially because that then required 3 separate probates, a probate for the deceased husband and a separate guardianship probate for each of the minor children. So by having a will or a trust in place, they probably could have avoided that result. And most likely, what many married couples do is they have a will that says, if I die, I leave everything to my spouse, otherwise in equal shares to my children. In this situation, mom had to wind up repurchasing the home back from her own children so she could become the sole owner. So you can see that there is a law out there that provides for these things, but it may not be the estate plan that you're looking for.
Right now that we have a general background about estate planning, we want to talk about planning for disability. And this is where all those powers of attorney and healthcare directives come in and become so important. So like Alan said, these powers of attorney and healthcare directives are valid during lifetime. So the will only upon death, the trust is like a super document because it plans for incapacity and death. And then these powers of attorney and healthcare directives are during lifetime. So what happens if you become incapacitated? So one way of planning for incapacity is that living trust that Alan just discussed. And the other ways for planning for disability are through powers of attorney. So here we have a power of attorney for property, a healthcare power of attorney, a HIPAA authorization, a declaration for mental health treatment, a living will declaration, and a DNR, or a do not resuscitate. And you can see that some of these are designated with an asterisk next to them. And those that have those asterisks are health-related medical documents that make up your advanced directives. So when they talk about advanced directives, they're talking about that healthcare power of attorney, the HIPAA authorization, the declaration for mental health treatment if you have one in place, the living will declaration if you have one in place, and a DNR, which is that do not resuscitate if you have one in place. And we're going to take each one of these powers of attorney and healthcare directives one at a time and have a discussion about the importance of each one of these. Importantly, you must create advanced directives and your powers of attorney while you are still able to make decisions for yourself. You cannot create a power of attorney for healthcare. You cannot create a power of attorney for property, a HIPAA authorization, a living will declaration. Any of these directives after an injury or an illness would prevent you from making your own decisions. So in other words, you must be mentally competent to create these powers of attorney and these advanced directives. So there's an emphasis on the fact that these should be done now. They should be done in advance. Pre-planning is important to do these and put these in place. If a crisis occurs, it will be too late if you cannot have the mental capacity to create them.
It's unfortunate too, because we do have families that come in and an individual is beyond the ability to create these documents, and there really isn't much that can be done at that point other than to petition the court to become that person's legal guardian. And then with that, you'll see when we start talking about the powers of attorney and the additional powers that you can add to them, a person is going to be limited anyway with what they can do especially in the area of long-term care and other issues like that. But let's start off with the power of attorney for property. It's also known as a financial power of attorney or a durable power of attorney. You may have heard that term, and durable just means it's going to be effective for you during lifetime, even if you become incapacitated. But that's really the point why you'd want the document. That's when it becomes the most important, of course. So all of the powers of attorney that we create are going to be durable in that sense, that they're going to be valid during your lifetime, even if you are incapacitated. And the financial power of attorney is a written document in which you name someone an agent. You give them the power to make financial decisions on your behalf. And this becomes especially important if you're unable to make those decisions for yourself. So you designate somebody as an agent, as a power of attorney, and they're going to have the ability to make financial decisions for you. You can set it up so they can do it out of convenience as well. So you don't have to necessarily be incapacitated. Maybe you're going to be traveling, abroad for 6 months for a work project, and you wanted to give somebody power of attorney here back in the United States at home in order to make financial decisions for you. But even more popular, it becomes very important if you're unable to make your own decisions, if you're in an accident, or maybe you have a cognitive impairment like dementia or Alzheimer's, and you're unable to make decisions for yourself. This document becomes very, very important. In general, it's going to be able to handle things like banking and financial transactions, dealing with taxes, dealing with the Department of Motor Vehicles, anything of a financial nature. And on this next slide, we're going to see all of the different things that an agent can do for you. So this listing is actually part of the Illinois statutory form. So these are all of the general powers that an agent is going to be given under the power of attorney for property. So the ability to handle real estate transactions, anything having to do with bank accounts or financial institution transactions, dealing with stocks and bonds, tangible personal property. That would be like your stuff, your car would fall under that category, your bicycle, your golf clubs, your jewelry, anything that's a personal property item. Dealing with safe deposit boxes, dealing with insurance and annuities, retirement plan transactions, dealing with Social Security, employment or military benefits, dealing with tax matters, handling any claims or litigation that might be pending for you, dealing with commodity and options transactions, business operations, the ability to borrow money, dealing with estates. And there's a general catch-all here at the end, all other property powers and transactions. However, in Illinois, if certain powers are not specifically provided for in the document, your agent may not be able to do that. So we do include a lot of additional powers. And we go to the next slide here. Some of those may include access to digital assets. We didn't see that on the prior slide because it's not contained in the statutory form. So we always add that as an additional power, the ability to access things online or do online banking or whatever might be required. The ability to make gifts. This becomes very important, especially in the area of estate tax planning or income tax planning, as well as long-term care planning, because if you're trying to have somebody who might be trying to qualify for, Medicaid or something like that, they may want to create a trust and gift some of their money into a Medicaid asset protection trust. So that power needs to be specifically provided for in the power of attorney, or your agent won't be able to do it. The ability to fund, let's say, a revocable living trust or any other type of trust that you might have. The ability to do long-term care planning, like applying for Social Security or disability or Medicaid. We've already mentioned the ability to enter into a caregiver agreement, especially if you wanted to allow for a family member to do that and get paid. Dealing with retirement plans, that is one that is on the standard form, but they don't really discuss what that means. So we like to, add more to that, like specifically give the authority to change beneficiary designations to make them in line with your will or your trust, or to do a Roth conversion. So we have all of these different things that we put in there to make the power of attorney more relevant. Access to safe deposit box, we like to expand on that. And then dealing with credit card companies. This is something that seems rather mundane, but let's say you became incapacitated and the credit card company or so any other vendor is refusing to talk with the person that you've designated. You want specific authority for them to be able to do that. So you can see by adding additional powers, you're making sure that your agent, the person that you've designated, is not going to run into a roadblock when they try to use the form, because the power will be specifically provided for.
So Alan just talked about the healthcare power of attorney for property, which was financial. So now we're going to switch gears to medical. And there's several medical or healthcare related documents that are part of your advanced directives and part of your planning for disability that should be done in advance. So we'll take a look at the healthcare power of attorney first. And that's also known as a medical power of attorney or a healthcare proxy. At Shire, we call them healthcare powers of attorney. And the healthcare power of attorney is a written document in which you give someone, and again, that person you are naming is your agent, the power to make decisions about your healthcare on your behalf if you become unable to make or communicate these decisions yourself. So as long as you can make your own decisions, you're going to make them. The healthcare power of attorney is not relevant. It's not in place. But what happens if for some reason you cannot make your own decisions medically? That's when it is essential that you have this healthcare power of attorney in place for you. It allows those agents, the people that you name, to step in and help out. And they can decide to accept, withdraw, or decline treatment for any kind of physical or mental condition that you might have on your behalf. They can agree to admit you or discharge you from a hospital or home or other institution. So for instance, if you're in one hospital and you need some kind of specialist care and it's at another hospital and your agent feels that you'd be better off and better served in the other hospital, they can make that determination for you and get you into the place that they feel is going to be in your best interest. They can have complete access to your medical and mental health records and share them with others as needed. This way they can act in your best interest, making decisions for you. And they can carry out plans you've already made, or if you haven't done so, they can make decisions about your body or remains, including organ, tissue, or whole body donation, or autopsy, cremation, and burial. But if you have made plans, if you're an organ donor, or you've made specific plans, then they would carry those out on your behalf for you. So as Alan said before, in Illinois, if you don't list specific powers, agents or the people that you're naming might not be able to step in and help with those powers. So as Alan said, we've seen before people who have powers of attorney in place, but a specific power that needs to be used isn't listed. So their agents is prevented from being able to act on that power. So we don't want that happening. So we add many, many additional powers to our powers of attorney. And for the healthcare power of attorney, we add things including the ability to hire a care manager. So that's somebody who can manage care. So if the agent felt like that would be important for you, they could go ahead and hire that care manager. Or if they felt that a companion would be helpful, they could go ahead and easily hire that companion because you've given them that power to do so in your power of attorney for healthcare. So patient advocates, very popular during COVID when you couldn't go in with a significant other, somebody on the inside of the hospital who can get information out about what's happening with you, with your case, with your treatment. And those patient advocates are registered nurses. And in the power of attorneys, when you list this as something that your agent can do on your behalf, hire on your behalf, you're giving them the ability to act in your best interest if they felt that a patient advocate would be helpful. They would have the ability to hire one because, again, you've given them the power to do so. Also, we add into powers of attorney for healthcare maintaining you in your residence. So if the hospital feels it's reasonable and you have a choice of staying in the hospital or going home, if it's reasonable, and that's going to be a doctor's determination, that you rather be at home. So if that's something that you believe, that would be something added to your power of attorney for healthcare. So we have many, many more additional powers that we add, but these are just a few examples of some things that we include in our powers of attorney for healthcare for our clients. So these become very important when you need them. Without them, like Alan said at the top of the presentation, you might have to go to court to get a guardianship in order to act on somebody's behalf. So having these in place ahead of time when you're mentally competent to put them in place is extremely important. So one of my girlfriends had a child who was going to a large university, and she wanted to help her get acclimated and suggested that she join a soccer intramural team because she loved playing soccer in high school. And this would be a good way to get to know some people and get out a little bit and get used to the school and surroundings. And my girlfriend's daughter thought that that was a great idea. And she went ahead and she did that. And she was having a great week and meeting girls and having fun. And the end of that week, in that last practice of the week, she collided with another one of her teammates and she got injured very badly. And she ended up at University Health Services in a situation where there was doctors that she didn't know, in a place she didn't know, never been away from home before. And she didn't understand what was being told to her. She couldn't make her own medical decisions. And fortunately, my friend had a power of attorney for healthcare in place for her daughter that she was able to send quickly to that hospital and make some decisions on behalf of her daughter because she was named as an agent who could do so. So that's one example of how important, real life example, these powers of attorney for healthcare go. That could be anybody. That could be a loved one who falls and trips and ends up in a hospital they haven't been in before. There's no paperwork there. So there's no way that they know who can be reached out to. So it's extremely important. Again, things happen, and really, if you never have to use these, that's totally, totally fine. But if you do, it's very important for them to be in place. So it's better to have them in place. Should something happen, should you not be able to make your own medical decisions, you want to have in place a document that says, these are the people that I want to step in on my behalf and make decisions for me. And then you also avoid the potential of somebody having to go to court and the expense and the time during the middle of a crisis for somebody to get a guardianship to be able to do that. So relatively simple to put these in place. So the power of attorney for healthcare is a decision-making document where you're naming people who can step in and make decisions for you should you not be able to make your own medical decisions. HIPAA is an information gathering document that's permitting people that you name to have your medical information. So I'm sure all of you have filled out HIPAA authorizations before at your doctor's office. It says it's okay for this nurse or this doctor to talk to these people about what's happening, my treatment. But we do these general HIPAA authorizations, right? Because you could be in a hospital you've never been in before. And at the time you enter, they could have no documents there that you filled out in the past. And you can't, when you enter, possibly say who it's okay, who has permission to call or fill out those documents. So these general HIPAA authorizations become very important. So HIPAA is the Health Insurance Portability and Accountability Act, but everybody knows it as HIPAA. And it's that written document that allows healthcare providers to release and share your medical information with the people you designate to receive this information on your behalf. Now, in your HIPAA, you can name as many people as you want as authorized recipients, and those people would be able to pick up the phone and call the hospital and get information about what's going on because they're authorized to do that. How this works practically is that you should have all of these documents electronically, because you can use electronic copies of these documents to send to a hospital. So if I'm authorized on your HIPAA authorization to receive information, I could send the electronic copy of the HIPAA to the hospital. They'd see my name as authorized, and then they could release the information to me. So that's how this works. So a lot of times people ask us, what documents can I share? What shouldn't I share? We will always recommend that the HIPAA is something that you might want to share with the people that you've authorized to get your information, and that somebody alternatively should know where you keep these documents. So if something happens to you, they can go and get them and get these documents to wherever they need to get to. So the HIPAA authorization authorizes the release of your protected medical information, including any kind of medical reports or records concerning your medical history, conditions, any kind of diagnostic or testing, treatments, billing information, the identity of healthcare providers, whether they're past, present, or future, as well as any other information that is in any way related to your healthcare, to only the people that you authorize to receive that information. So somebody needed to know something about you and what was going on with you, you'd want to make sure that you list them on the HIPAA authorization as authorized so they could get that information. So I can give you a personal example of having to use the HIPAA authorization, and that is when I had to use it for my son, who was at a university, and he was not feeling well, and he just didn't seek medical attention, even though I had asked him to. And by the end of the week, he'd gotten really sick. And I got a call from him early morning, which you never want to get a call then. And he had said that I should not worry about him. He was going to the emergency room. He really didn't feel well. And he had his cell phone, but he forgot to take his charger, and the cell phone was almost out of battery. And he was going with a friend, and the friend would keep in touch with me. So of course, you're concerned when you get a call like that. And I waited and waited and did not hear anything for a while, until I got a text from his friend who said, "We are in the emergency room. I don't know what's going on. They won't give me any information because I'm not authorized to receive any information." So I quickly called up to the hospital, and I called the nurse's station, and they said, "We can't even tell you if your son was admitted until we have a HIPAA authorization that states that you're authorized to get that information." So thankfully I had them again. The electronic copy is very important. I was able to send that right to that hospital and to call back, and the nurse apologized and said, "Sorry, but without this HIPAA authorization, where we can see that you're an authorized recipient, we can't tell you anything." So I can tell you from personal experience, and we can tell you from many experience with our clients, that the release of medical information without a HIPAA authorization could require, again, a lot of hoops to be jumped through, where in the middle of a crisis, all you want to be doing is being able to get information immediately. And things happen. I mean, people say, "Oh, I have my phone, it's going to be okay." But in that case, there was no battery. So things happen. And one way to avoid some of these crisis situations is just to put these documents in place. So the next document that is part of your advanced directives and a healthcare directive is the living will declaration. And there's a lot of confusion with this. People a lot of times think it's a trust, because sometimes people refer to trusts as living trusts or living revocable trust. And it also gets confused because it says will. And some people think it's part of the last will and testament that Alan talked about, but it is actually a healthcare directive, which states your wishes regarding life support in the event you're in a persistent vegetative state or irreversible coma and cannot communicate your wishes. It's a standalone document. When you go in the hospital, they say, "Do you have a living will declaration?" That's what that is. And the living will declaration says that if any time I should have an incurable or irreversible injury, disease, or illness that is judged to be a terminal condition by my attending physician, who has personally examined me and has determined that my death is imminent, except for death delaying procedures, I direct that such procedures, which would only prolong the dying process, be withheld or withdrawn, and that I be permitted to die naturally with only the administration of medication, sustenance, or the performance of any medical procedure deemed necessary by my attending physician to provide me with comfort care. So if you agree with that statement, you could put a living will declaration in place. If you don't agree with that statement, you just wouldn't have this as part of your healthcare directives. In Illinois, there's also a declaration for mental health treatment. If this is something that is relevant for you, you could put this in place. The Declaration for Mental Health Treatment allows you to choose whether you would want to receive electroconvulsive treatment known as ECT or psychotropic medicine if you have a mental illness and are unable to make decisions for yourself. And you can write on the Declaration for Mental Health Treatment your wishes or choose someone to make your medical health decisions for you in this regard. So if this is a document that would be relevant to you, Illinois does have this declaration available to be part of your healthcare directives. There is a lot of confusion with DNRs, do not resuscitate. A lot of people get this confused with the living will declaration. A DNR is actually a medical document or order which tells doctors not to restart your heart or your breathing. So normally a doctor is going to give CPR when you stop breathing or your heart stops. The DNR would tell them not to do that. The DNRs are not a document that we would put together. It is an order from a physician and it has to be signed by your physician. You do not want a DNR in place if you would want your breathing to be restarted or your heart to be restarted. So people who might want a DNR, maybe somebody who's in the end stage of a terminal illness or has had multiple heart attacks, and if they had one more, they just wouldn't want to be resuscitated. So those would be the cases that you might want to put a DNR in place. So again, you do not want to sign one of these unless you're sure that you would want a do not resuscitate order in place.
And we do have a lot of clients that come in that are confused about this, and because they would say, yeah, I want to do a DNR, and maybe they're 52 years old and they're perfectly healthy, and you really wouldn't want a DNR in that situation because you probably would want to be resuscitated. So there is a spot on the form that says, yes, I do want to be resuscitated, but we don't advise doing it that way. We just advise not having the document at all if you don't want it, because there could be some confusion with the paramedics and maybe they don't read it fully. So only use a DNR if you do not want to be resuscitated and you have, medical reasons for that. So,
yeah.
We also get questions sometimes about, okay, I live in Illinois right now. If I do, these powers of attorney and healthcare directives, and then, 2 years from now, I wind up moving to, Texas or Tennessee or Florida or Michigan or Wisconsin or any other state that I could name, do we have to redo these forms? And the good news is that the forms, as long as they're validly executed here in Illinois, they're going to be valid in all 50 states. In fact, we add a section to the statutory form that says it's my intent that this form be valid in all 50 states and jurisdictions. So this way you don't have to worry about updating it. We do recommend, though, that these forms get updated, so they're not stale, once every 3 to 5 years, if you're super careful about it. If you have a 20-year-old power of attorney or healthcare directive, there may be some doubt on the recipient as to whether or not it's still valid or hasn't been otherwise revoked, right? So we do recommend, because it's not super expensive to get those taken care of and updating them periodically, but there is no expiration date on them either. So they don't expire like after 2 years or anything like that. They're good until you revoke them or do a new one. We also get questions, well, what happens if, carted off to the hospital and I'm in a coma and I don't have any of these documents in place? Won't the hospital just listen to whatever my spouse or my family has to say? And the answer is yes. There is what's called a surrogacy statute in Illinois that has a pecking order of who could be a decision maker, and we have that listed over here. However, we wouldn't want people to rely on this because anyone acting under this surrogacy law is going to have limited powers, not the same amount of power that could be designated by virtue of having a healthcare power of attorney, let's say. So we always recommend that as being the better option. The other issue is that, by doing the forms in advance, you're the one who's in control because you're designating the person that you want. You may have a very assertive person in your life that maybe you wouldn't want making these decisions, but if something were to happen to you, they may be the person that steps up and starts making them because they're assertive. And maybe someone that you would want to make that decision may be less assertive and wouldn't necessarily stand up. So it's always nice when you can pick the person that you want to make those decisions, whether or not they conform with that pecking order that we just saw. The other issue is that your family members may not be able to agree on your medical care. So if you have no healthcare power of attorney and you have your spouse acting as the decision maker, but the children disagree with the course that the spouse is taking, then you have a problem there. So by designating an individual that you want to make the decisions, you're taking that off the table. So that's always a good way to do this. Without it, you could have emotional stress for the family member. You may also designate a person that's not necessarily, a person that may be called upon who's not necessarily ready to make that decision. So when we prepare these documents for clients, we always recommend that if you're going to designate person A to be your agent to make medical decisions, maybe you want to have a discussion with them and let them know you're doing that and make sure that they're comfortable with it before you do that. So again, preparation in advance is really going to be the key. If there's a disagreement among loved ones, or if a certain financial or medical decisions are required of a guardian, of somebody, and no one can make the decision, then a court is going to have to appoint a guardian. And then the guardian may be able to do things on your behalf, but some of those things may require a court order. So you have like delay and other issues, plus the fact that getting a guardianship is going to be expensive and time consuming. So it's always there as a fallback, but you wouldn't want to rely on that to be your estate planning choice.
So the way in which these advanced directives and powers of attorney coordinate with your family priorities is very important, because they allow you, again, like Alan was just alluding to, appointing the agents you desire to step in on your behalf for any kind of financial and medical affairs. So it's important that you have the people in those positions that you want there, that you trust there, that you feel are going to make those best decisions for you when you might not be able to make them on your own. They provide direction as to life-sustaining treatment and other personal choices. So you're giving direction to your agents about how you feel about life-sustaining treatments and other choices that you have that they might have to make on your behalf. You can decide who's authorized to get your protected health information, who can call up that hospital and get information about what is happening with you. And you give your agents decision-making ability while you have the mental capacity and the ability to authorize those agent powers. Again, you're avoiding people having to go to court, get a guardianship, potential disagreements like Alan was just discussing. So all in all of these protections for your powers of attorney and your advanced directives, which they're providing to you, are allowing you to make your own decisions about who you want to step in and make decisions for you and how you want them to make those decisions on your behalf. So these documents, it's all about peace of mind. We always say that with all of our clients. Estate planning is all about peace of mind. These powers of attorney, these healthcare directives, all about that peace of mind. They allow you to have immediate decisions made and give access to critical information if a crisis occurs, so your loved ones can focus on the situation at hand while they're helping you out in the way that you envision. They're relatively easy to put in place. They should be among the top of everybody's list, and they should be kept in a safe and easily accessible place. And we always recommend to our clients that you keep them electronically. And if you give those HIPAA authorizations to others, make sure that they know where they are just in case they need to use them on your behalf. So this is also something we wanted to bring to you, because a lot of people don't realize that they have this resource at their fingertips. This is the Medical ID app. And if you have an iPhone, you will see this icon. It's a white box with that little heart in the middle. And if you don't have an iPhone, you have another type of smartphone, you can download a similar Medical ID app. And the Medical ID app allows first responders to bypass a lock screen, whether it's facial recognition or a code or otherwise, and get directly into whatever information is placed into that app. So if you have a medical condition, if you're allergic to a particular medication, if you have an allergy to a food, anything else that first responder would need to know, you could put that information into the medical ID app. They are trained to look for this app. They are trained to access it. We don't necessarily advocate whether you use it or you don't use it or how you use it, but it is a great resource, and we just wanted to make you all aware of it if you want to utilize it, especially if you have some kind of condition or allergy to something that a first responder would need to know. So everybody asks us all the time, what is the ideal family estate plan? So like Alan touched on at the top of the presentation, having a will or a living trust in place. And then importantly, as we discussed today, that power of attorney for property to help out with financial affairs if you need that assistance, the power of attorney for healthcare. If you cannot make your own medical decisions, you are designating those people who could step in and make them for you. The HIPAA authorization, who's designated to be able to call up that hospital and get information about what's happening with you. The living will declaration, if that's something that you believe that if you have an incurable or irreversible injury or disease that you would want to be able to die naturally, you could put that living will declaration in place. Also, assignments and deeds and beneficiary designations, long-term care planning, maybe some irrevocable trusts, and just to roadmap your estate plan. So just making sure that the people around you know what's part of your estate plan and where important documents and the like are kept. So this roadmap is a place where anything that is not known readily to somebody, you could place things like, where are those important documents? Who are your important contacts? You know, anything that you would want somebody to know should something happen to you, you could create a little roadmap. We have ones that we do for our clients, but it can be anything. It could be, you know, an Excel sheet. It could be something you write down on a piece of paper if you want people to know about different assets that you might have. You don't necessarily have to tell them, you know, how much they are, but you just might be somebody you want aware of what's out there should something happen to you. If you have a safety deposit box, things like that. So sort of a catch-all.
Don't forget the cash that's in the mayonnaise jar. You know?
Exactly.
So things like that, or was something buried in the backyard or whatever.
Yep.
So it's really a great opportunity to kind of bridge the gap between the legal documents and what's important to your family and making sure that they get the information that they need to move forward. So
You can even put things in there like the importance of a family heirloom, you know, things like that. So just something to think about as you're thinking about putting together some of these documents. So any questions?
I think we did an amazing job because there are no questions.
No questions. Well, if you have questions, we really welcome questions. We want to make sure that you understand all these different documents, how they coordinate, how they work. So anytime we welcome your questions, you can call us, you can email us. Again, our phone number 847-955-9000, or email us your questions at Caren, C-A-R-E-N again, at shirelawgroup.com, or Alan, A-L-A-N, at shirelawgroup.com. And we thank you for spending a little bit of time this afternoon with us. We appreciate it.
Thank you.
Hi, it's Tamara here, and I want to thank all our participants that joined us today, and I hope you learned some things. I know I did. It was very informative, and I want to thank Alan and Caren today for the presentation. And I see there is something in chat here. Let me look here. Kelly asks, can you have more than one person on your POAs?
So you cannot name co-agents, but you can name as many people as you want in succession order. So the person that you would want to act first, you put first. If they're unavailable, then the successor agent. If they're unavailable, then the next one. It doesn't mean that people can't talk to one another, but they're going to look to the first person that's named to make that decision. Now, the HIPAA authorization, you can name as many people as you want, and all those people named have that same right to call up the hospital. There's no particular order there.
And one of the reasons for the reason you can only have one agent at a time is because the legislature is concerned that if there's a disagreement between co-agents, you might be rendering that form useless because nobody can make a decision. So they're trying to avoid that. So we do have many situations where clients would like to name co-agents, but we explain that to them and the fact that the family can still work together. Just at the end of the day, there's one decision maker that's going to be able to, execute the document, so to speak.
Great question.
Yeah, thanks for the question, Kelly. Oh, it looks like there's another one here. Hold on in the chat. Mary asks, is it possible to get a copy of the PowerPoint? There are lists there that would be helpful to have. Thank you.
Yeah, what we can do is we'll send over to you, Tamara, like a PDF version of this, and then you can distribute that out to the participants.
All right, I'll be happy to do so. Victoria has a question. If there is a dispute between organ donation between a boyfriend, girlfriend, and the person's family, what happens?
Well, someone's an organ donor and they've designated that with the registry, that's going to prevail, of course. But let's say they haven't done that, and really the only thing that's there is the power of attorney. Then whomever is designated as the agent under that healthcare power of attorney is going to have the ability to make that decision. So if you do want to be an organ donor, you should be registered with the registry, and you can put it on your license and all of that. That's probably the best course of action. If there's a dispute, regarding that, I think the actual registration would prevail, to my knowledge. But if it doesn't, or if they're not registered, again, it would be whomever has the power under the power of attorney would have the preference. If there is no power of attorney, then that pecking order that we showed, spouse would come first. That's the listing that you would look at, I guess, to make that decision.
Okay.
But always better to have the forms in place and have it preset,
Right.
so you don't run into an issue like that.
Right. Yeah, very, very much so. Okay, if there's any more questions, if not, we'll go ahead, and I want to thank Alan and Caren again today. It was very informative and enjoyable. And thank you for being a resource of ElderWorks. We really appreciate that.
Our pleasure.
Yeah, thank you so much. It was our pleasure to be here today.
Thank you.
Thanks, everybody.
Thank you, everybody.